We are now switching to the last session, which is dedicated to internet domain names. And this is surely something some of our viewers were expecting from the very beginning, given that our co-organizer is the Serbian Internet Domain Name Registry Foundation. In this third session, we have three speakers. First, Professor and attorney Alexandre Cruquenaire from Belgium, attorney partner at Lexing, Belgium, and professor at the University of Namur. Then my colleague Marko Jovanović, who is associate professor here at the University of Belgrade Faculty of Law. And finally, Mr. Dejan Đukić, acting director of the Serbian Internet Domain Name Registry Foundation and head of legal department. We'll start with our guest from Belgium. I will repeat what I've said at the very beginning to the judge Kovalik Bancic. I'm very grateful to Professor Cruquenaire that he accepted our invitation and dedicated some time to participate in this online event. I do hope that we will be able to host him in Belgrade for our next conference. I would kindly appeal to all the three speakers to respect the time limit of, let's say, 10 minutes, given that our Zoom session will going to end at some point. Without any ado, I give the floor to Dr. Alexandre Cruquenaire.
Thank you very much, Professor. I'm very very glad to participate to your event. Unfortunately, it's not an opportunity for me to visit Belgrade, but it will be next time. So to stick with the timing, I will go directly to the topic. So as you know, intellectual property and domain names are not always the best friends. So there are many disputes regarding the infringement of IPR and in particular trademark in the field of domain names. So when the ICANN decided in 2011 to initiate a process for creating a new top-level domains, of course there were many concerns from IPR owners regarding the protection of their rights, and for that reason, ICANN took the concern very seriously, and they created specific dispute resolution mechanism, and that's what I'm proposing to briefly discuss with you. So ICANN received more than 1,200 applications for their new program. So more specifically, they delegated more than 1,200. So it's quite a lot compared with the initial expectations. You can move to next slide. And regarding the management of the dispute, so could you move to next slide, please? Thank you. So ICANN created 4 different procedures, which are named objection procedure, which ground vary depending on what ICANN wants to protect. So for IP rights, it's mainly for the first and second objections. These 2 are more relevant, and the 2 others are more for your information. They are less relevant in terms of IPR protection. You can move to next slide. So ICANN appointed different bodies to manage these different types of objection. You can move to next slide. So the first one, which is string confusion objection. The topic here is to allow an entity which is currently operating an existing top-level domain to object against an application for a new top-level domain, or it also allows one applicant to a new top-level domain to object against another application in the same round of application when it is covering, for instance, the same string or a similar string, which may cause a confusion. So the standards for that kind of objection is to establish that there is a similarity between the strings, and due to that similarity, there is a likelihood of confusion. Can move to next slide, please. So if we compare with the traditional trademark case law, the standards which are used by the panels to make decisions on these objections are more or less similar to the usual standards of trademark law, but there are some differences, as you can see on the next slide. So the main difference here, even if the objective of ICANN in this in the framework of this string confusion objection, the aim of ICANN was to more or less align on the trademark case law. The review of the decisions made by the different panels shows that there are some differences, and in particular the fact that the standard for the likelihood of confusion seems higher in the framework of this objection than the usual standard in the trademark case law. And another difference is the reference to the average internet user to assess the existence of a likelihood of confusion, instead of, like in the usual trademark case law, to refer to the average buyer, the average consumer of the services or products which are concerned by the trademark. So for the sign here, the services to be purchased are the domain name. So instead of referring to an average buyer of domain name, it is referring to an average internet user, which of course makes some difference in the appreciation of the likelihood of confusion. So that's for the string confusion objection. For the second type of objection, legal rights objection, which is probably the main one for protection of trademarks. In that situation, in the framework of this objection, two different type of objectors are allowed to file an objection. First, it is available for intergovernmental organizations, and what is the most relevant here for our discussion, it is open for right owners, for IP owners, for trademark owners to file an objection against a new top-level domain which is proposed in the framework of an application. So what are the standards to object here? So the trademark owner has to prove that the proposed new top-level domain would take an unfair advantage of the reputation or the distinctive character of its sign, or it would cause some damage to the same distinctive character. So it's quite similar to the standards we have usually in trademark law. And also another standard is the evidence of an unacceptable likelihood of confusion with the objector's sign. So the dispute resolution service provider here is the WIPO. And the assessment of the standards by the panels is based on a non-exhaustive list of 8 factors that you can see on the slide. I will not review them in detail, of course, due to the timing. But you can note that it has many similarities with the UDRP procedure you are probably familiar with, which scope is to settle the dispute for abusive registration of generic domain names. So of course the ICANN took the advantage of this experience of the UDRP and the success of the UDRP procedure when designing this objection. So when the objection is filed by an intergovernmental organization, the factors to be taken into consideration are not the same. So I refer to my slides. Very rapidly for the two remaining objections, which are also possible in this process. You have, so it's on slide 11. You have the limited public interest objection. So here the standard is to object against an application for a new top-level domain name, which would be contrary to morality or to public order. So it's not connected to IPR, so I will not develop it further. And finally, on slide 12, you have the community objection. Here, the idea is to allow an entity which can establish that it is representative from a specific community, that an application for a new top-level domain may be detrimental to the interest of a significant portion of the concerned community. So this type of dispute, of course, is very complex to settle. And the case law resulting from this procedure is very interesting to review. So for that, you can, and I will finish by this final remark. For further information on these different procedure and the case law, I kindly invite you to refer to the book I published 5 years ago on this case law. So it's on, you have the references on slide 15. So this book is published in French, but I have to inform you that we have an agreement from the publisher to publish on internet an English translation. And this English translation will be available soon on my law firm website using the URL that is mentioned on the slide. So thank you very much for your attention. And of course, I remain available to answer your questions. Thank you very much.
Thank you, Dr. Cruquenaire, for your insightful presentation on the objection case law. And thank you for being within the time limits. So we will now switch to another topic, which is not necessarily related to the previous one, but it is related to domain names. That is why we have Associate Professor Marko Jovanović joining us from this very same building, but another floor. And Professor Jovanović, will speak about private international law aspects of domain name disputes. The floor is yours.
Thank you, Professor, and thank you for your invitation to take part at this conference. So, as you have said, I will stay in the realm of domain name disputes, but I will tackle that issue from a somewhat different angle, from the angle of private international law. So usually, whenever private international law is mentioned, that sets off the alarm in the ears of the audience. A mere reference to private international law is often a signal that things will become more difficult or unreasonably complicated. I will try to prove that this doesn't hold true, at least in case of domain name disputes which are settled by alternative dispute settlement bodies. The things become more complex, indeed, because there is another set of questions which is involved, but they do not become that difficult or that complicated. Let me move to my first slide, which is already in front of you, actually. So if we can go to the previous slide with the preliminary remarks. I will deal only, yes, thank you. I will deal only with, there are several types of domain name disputes, and the main classification is based upon the fact whether the domain name holder has acted in good faith or not. I will deal only with those disputes where the domain name holder has not acted in good faith, because those are the disputes which can be resolved by alternative dispute settlement bodies. So for the purposes of this presentation, the domain name dispute will be the one which is defined on this slide. Question also arises as to how do we come to private international law in terms of disputes. Most often it will happen due to the localization of the party to the dispute, either the complainant or the domain name holder. They can be of different nationalities, they can be physically located abroad in terms of their habitual residence or their domicile, but most often the foreign element will lie there. That is not necessarily the only place for the foreign element, but it is the characteristic and the most common place. So that was the initial setting. We have defined the disputes that we will deal with, and we have explained how we come to private international law matters. And now I will pass to some specific issues that may become more complex in the presence of the foreign element. And the first one is in front of you, and that is the service of documents. Normally, if the disputes are settled before courts and by the courts, there will be two main problems which are linked with the service of documents in private international law matters. That would be the length of the procedure for service of documents and the requirements of special form of service, which is somewhat connected with the length. Normally, we would follow the path which is prescribed by the relevant international treaty, or in the absence of such treaty, we would resort to the diplomatic means and diplomatic form of service. That is of particular importance in court proceedings because some countries, for example, Switzerland, maintain that the breach of the rules on cross-border service of documents can be the reason for lodging a diplomatic protest against the country which attempted the service of documents in breach of the relevant rules. Luckily, in terms of domain name disputes settled by alternative bodies, these problems do not exist. Not only because these are the alternative bodies which follow a somewhat more relaxed form of service of documents, but because we are dealing with domain name disputes and the relevant rule books have deemed that it would be only natural to introduce the electronic form of service. That is the form of service which is accepted by UDRP rules. That is the form of service which is accepted by all the rule books which are based on the UDRP system, including the Serbian one.
I hope that you remember that in the beginning of my presentation, I said that the parties to the proceedings may often be foreigners. So that entails the problems with the question of language. The Serbian rules deal with that problem in the way that they prescribe that the proceedings shall be conducted in Serbian language. That leads to the question of whether the parties can deviate from that provision, and if so, who would organize and bear the costs of translation. It seems to me that the wording of the provision, the proceedings shall be conducted in Serbian language, does not leave room for any deviation. If the deviation could be possible, that would entail some other problems, such as the language competence of the arbitrators, of the panel who decides the case. Nevertheless, if one of the parties speaks a foreign language and is in need of translation, then that party would have to organize and bear the costs of translation. That might pose some additional problems because, at least under Serbian rules, the dispute settlement body, the Committee for Resolution of Domain Name Disputes, cannot award costs for the proceedings. So that could be an additional factor of complication in case this question arises. The UDRP rules take a more flexible approach, and they say that unless otherwise agreed, so they explicitly leave room for a different agreement, the language of the proceedings shall be the language of the registration agreement, and they allow the panel to decide otherwise if the circumstances so dictate. As far as the place of the proceedings is concerned, the fact that these proceedings are often conducted in an online environment also eliminates some of the difficulties that could be involved when there is a private international law element. The in-person hearings will be conducted only if that is required by the parties or decided by the panel. They are not mandatory, so it may well happen that the dispute is resolved without in-person hearings, which then significantly helps resolving some private international law complications that may arise out of the fact that one or both of the parties are not located in the country of the proceedings. Let us move to the next slide, please. Next slide deals with the question of applicable law, which is often the most difficult and the most delicate issue of private international law cases. Here, those concerns actually do not exist. As far as the procedure is concerned, the rule books are very detailed when it comes to the procedural solutions. So there would be very little room to resort to national rules if that is envisageable at all. As far as the merits are concerned, where the question of determining the applicable law can come into place, here the rule books actually specify the points that need to be proven. And since the scope of competence is very limited, the question of resorting to various elements of the applicable law actually is not in place. So that leads me to my last slide and a couple of conclusions that I would like to leave you with. The domain name disputes do leave room for raising private international law problems and concerns. However, these concerns, in case of alternative dispute settlement bodies, have a much smaller impact than it is the case when those disputes are resolved by the courts. The most significant problem that may arise will be the prolongation of some phases of the proceedings, but not all proceedings, and the increase of costs, again, of some parts of the proceedings, but not every element of the proceedings. With this, I would like to leave you, and I would like to thank Professor Popović for giving me this opportunity to continue my presentation. Thank you.
I kindly invite Mr. Dejan Đukić, the Acting Director and Head of Legal Department of the Serbian Internet Domain Name Registry Foundation to join us. I'm sure that the internet works very well at the Serbian Internet Domain Name Foundation. Yes, definitely. Mr. Đukić will speak about content blocking, the registry's position. So we hear all the time that the domain name registry operators are avoiding the topic of content. So how successfully are you avoiding this topic?
I'll try to explain. Thank you, Professor, for the invitation and giving me the opportunity to speak at this conference. Next slide, please. So some quick facts at the beginning about the registry. We are a private, not-for-profit organization, non-governmental organization. The registry established the policies by itself, and in Serbia there is no related domain name law. By national jurisdiction, a registry is part of critical infrastructure. In our case and in our policy, we are practicing registrar model. So there are no direct registration to the registry. The users need to register domain name via registrars. In most cases, they are hosting or internet service providers from Serbia. For the registrants, we don't have any limitations. So from any part in the world, users can register both our domain names. Next slide, please. When we speak about parties who are involved in making content available or online, there are three main parties in that case. So content providers, which is in most cases subjects who generate or create the content, and he's dealing with the publishing and making that content online, whether it's legal or illegal. The next party is hosting provider. It is service provider who helps that making a website or some platform be seen online. And the third party is internet service provider who offers the services of access to the internet. Next slide, please. And when we speak about domain name system, DNS system, on the other hand, is not directly involved in publishing content online. It is part of the internet infrastructure. And in next couple of minutes, I will show you a video that explains how DNS works. So could you please press that link in a slide?
Computers and other devices use IP addresses to identify each other on the internet. As we can't always remember complicated numbers, we use words instead. The domain name system brings the two together to get you to your destination. This is how it works. All around us we see domain names. For example, the website of your favorite band. The site is stored somewhere on the internet. Let me explain how your PC finds it within milliseconds. The journey starts with typing in the website address. In words, of course, as you wouldn't have remembered IP 88.151.243.8. Your device will read the address backwards. It will start at the end with the root domain, in our case, .eu. Information on the root domains is stored in 13 different root servers located around the world. In reality, there are numerous more copies of each of these machines in different locations to make sure that whatever happens, the system will keep on working. A root server contains the information on the name servers for the different zones. In our case, it tells us where we can find the information on addresses ending with .eu. Again, for reasons of security, there are a number of these .eu name servers located around the world, so that if one is too busy or stops working, for example, due to an earthquake, the information would still be reachable elsewhere. The .eu name server knows where the information for the more than 3 million .eu addresses is stored, and will tell us where we can find flamingflamingos.eu. It will communicate this unique IP address. The IP address for the Flaming Flamingos website is now identified and sent to your computer. Now the download of the content can start. But remember, this whole process that makes it possible to connect your computer to the place where the website is stored happens in just a few milliseconds before it connects to the internet and starts downloading the information. In reality, a lot of information is stored along the road in the so-called cache memories, so that the information can be retrieved faster than having to return to the root every time. This movie is brought to you by CENTR, the organization of European country code top-level domains.
And Serbian CCTLD, like other CCTLDs, is in position that it's not directly involved in content publishing. We are not doing any checking or approving content publishing before it's online. But on the other hand, we have few right protection mechanisms that unsatisfied party can use in content blocking and settle those disputes. Next slide, please. According to our general terms and condition, besides registrant request, domain name data can be changed according to alternative domain name dispute resolution decision of the competent court of competent public prosecutor, and after internal data accuracy checking. Next slide, please. And on this slide, there are few cases that are in some way were content related. So first one was settled via our ADR court. Marko told few words about that, but it is sort of UDRP panel that we are settling issues and disputes regarding .rs and SRB. And in this case, there were mainly content-related dispute. A company, which is famous media company from Serbia, didn't have the registered domain name on this slide. And can you return slide? Okay. And this company failed to register domain name. They are at the moment are not interested to register it, and it was free to register. And some user register that domain name, and for some period publishing content, which is by design. And when you look at first sight, pretty same like this website of this company, but news were pretty different, a lot of fake news and a lot of violation of local laws. And company didn't have any other choice than to start UDRP process. And after the process is done, they are registered that domain name on this media company. Also, there were a few disputes related to content, but those were not directly related to domain name itself, and they were not settled via ADR panel in Serbia. For example, we have a lot of challenges with unions, and because unions are not registered in a public register, and it's really complicated to check data who is a person who has right to sign and no decisions and letters on union's behalf. And if you ask the Ministry of Justice, they will give you the answer that unions are independent and they have some register, but that it's not public and it's not easy to check who is representative of the unions. And in some cases, there were some changes of management of unions, and in a few days and a few weeks, we received like 10 letters from different representatives unions with the requests to change DNS data. And in those cases, if you change DNS data and administrative contact, a person who is administrative contact can change DNS data and publish different contact than the other person. And in those cases, we are receiving different letters several days, and as with request to change one day to another administrative contact, second day to the first one, and it was pretty complicated to find a way to respond on those requests. And we are close to the end of my presentation. So thank you for your patience, and if you have any questions, I'll be happy to answer.
Thank you very much. We have one question that we received by email for participants in this session. In particular, this is the question for Professor Cruquenaire, and it is actually connected to the presentation by Mr. Đukić. So the question for you, Professor Cruquenaire, is whether you're familiar with the way in which Belgium domain name registry deals with cases related to content of the website.
Good point. So as it was mentioned for the Serbian registry, the experience of the Belgian registrar, so DNS-BE, is rather similar. So the idea is not to take part to that kind of dispute and to leave to stay in a position where you are just an intermediary and not without any direct control on the content. However, some courts are requesting from the registry to block some domains, and in this situation, of course, the registry is implementing the court decisions, and it's also addressed in the general terms and conditions, of course, of the registry, that in case of court order, the domain name can be blocked by the registry without any compensation to the owner of the domain.
Thank you very much. I would like to thank all the three participants, and to Professor Cruquenaire, I would say see you very soon, I hope, in Belgrade. So we are counting on two things, that this epidemic will be over at some point soon, and that you will come to our conference in Belgrade. Stigli smo do kraja naše konferencije. Naravno, kako je to uvek slučaj sa naučnim skupovima, malo smo probili termin, pola sata duže. Ja vas podsjećam još jednom da mnogo iscrpnije o svim ovim temama možete pročitati u zborniku radova Intelektualna svojina internet 2020. godine, koji je u prodaji u knjižari u zgradi Pravnog fakulteta, ili se može naručiti preko internet knjižare na sajtu Pravnog fakulteta Univerziteta u Beogradu. Molim vas da nam oprostite za sve tehničke greške. Mi smo samo skup profesora prava koji pokušava da rukuje jednostavnom tehnologijom, ali naravno uvek problema ima. Ukoliko gledate snimak ove konferencije, svi problemi će nestati u režiji, a oni koji su se interesovali za naše PowerPoint prezentacije, ponavljam, dakle, da će u tom snimku te prezentacije biti bolje umiksovane, zauzimaće čitav ekran, tako da ćete moći da ih pročitate. I pozivam vas da i dalje pratite ono što radimo. Znate da je ova konferencija od 2018. godine ušla u režim dvogodišnjeg bijenalnog događaja, dakle naredna konferencija je 2022. Tada valjda korone neće biti, ali vidjet ćemo se i pre 2022. zato što u ovim neparnim godinama, dakle 2021. sa Fondacijom Registar nacionalnog internet domena Srbije organizujemo internet dijalog. To je jedan drugi format konferencije koja po pravilu je manje posvećena pravu intelektualne svojine, a više nekim drugim temama koje naravno imaju veze sa internetom. Tako da vam ja zakazujem novi sastanak sa nama i RNIDS-om u junu 2021. godine, a do tada čuvajte se. Doviđenja.